3, 2, 1, start. Submission of the learned counsel for the petitioner is that despite the order dated 27 February 2023 of respondent number 2 for redetermination of compensation of the same was not paid to him, stop. Learned counsel for respondent number 3 contended that as respondent number 3 has filed reference under section 28A within bracket 3 of the Act 1894 against redetermined award dated 27 February 2023 by respondent number 3, therefore till the decision of the aforesaid reference enhanced amount of compensation cannot be disbursed to the petitioner, stop. However, learned standing counsel has stated that SLO has already written a letter dated 27 February 2023 to respondent number 3 to deposit the compensation as per the order dated 27 to 2023 so that the same could be disbursed to the petitioner, stop. But it is respondent number 3 who has not deposited the compensation of the petitioner, and for these reasons the same could not be paid to him, stop stanza. Learned counsel for respondent number 3 in support of his contention relied upon the judgment of this court passed in first appeal number 305 of 2022 bracket start UP आवास एवं विकास परिषद वर्सेस मोहम्मद याकूब एंड अदर्स AIR 2022 ALL 291 bracket close decided on 3 June 2022 and contended that the division bench while passing the above judgment clearly observed that at the instance of the beneficiary of the acquired land, though appeal under section 54 of the Act 1894 is not maintainable, there is a remedy to file an application for reference under section 28A within bracket 3 of the Act 1894, stop. It was further submitted by learned counsel for respondent number 3 that Honorable Supreme Court in the judgment of Sekhar Resorts Limited versus Union of India reported in MANU SC 0015 2023 as well as this High Court in Yogesh Agarwal versus State Officers and others reported in MANU UP 1620 2015 held that no party can be left remediless for operation of law, therefore in absence of any other provision against the order passed under section 28A within bracket 2 of the Act 1894, application for reference is maintainable under section 28A within bracket 3 of the Act 1894 at the instance of beneficiary of acquired land, stop stanza. In reply to the objection of respondent number 3, learned counsel for the petitioner specifically submitted that the application for reference under section 28A within bracket 3 of the Act 1894 against the order passed under section 28A within bracket 2 is not maintainable at the instance of the beneficiary of the acquired land, because that provision is for the benefit of land owners whose land has been acquired and the beneficiary does not come within the definition of interested person. Stop. It was further submitted by learned counsel for the petitioner that even if it is accepted for the sake of argument that the reference is maintainable, even then reference court cannot reduce the amount of compensation as determined by the collector because of the provision of section 25 of the Act 1894. Stop. Therefore, there is no reason to file an application for reference by the respondent number 3 under section 28A within bracket 3 of the Act 1894, and the entire exercise is being conducted by respondent number 3 just to delay the disbursal of the amount of compensation to the petitioner. Stop. Stanza. After considering the submission as well as on perusal of record, the only issue for redetermination in the present case arises is whether the application for reference under section 28A within bracket 3 of the Act 1894 is maintainable at the instance of the beneficiary of land within bracket respondent number 3. Stop. It would be relevant to reproduce section 28A of the Act 1894, and the same is being reproduced as under section 28A. Stop. Redetermination of the amount of compensation on the basis of the award of the court. Stop. Where an award under this part the court allows to the applicant any amount of compensation in excess of the amount awarded by the collector under section 11, the persons interested in all the other land covered by the same notification under section 4 subsection within bracket 1 and who are also aggrieved by the award of the collector may, notwithstanding that they had not made an application to the collector under section 18 by written application to the collector within 3 months from the date of the award of the court, require that the amount of compensation payable to them may be redetermined on the basis of the amount of compensation awarded by the court. Stop. Over.